The next case is Christopher Crandall versus Elizanna Crandall. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know as I will be keeping track of the time. The arguments are being recorded. Please keep your voice up and remain behind the podium. You should not use the names of children, minors, and victims during your argument. You can refer to them by initials or terms like the child. The judges have read your briefs and are ready to proceed.
Thank you, Your Honors. Joseph Stafford on behalf of the appellant Christopher Crandall. What's unique about this case is that it's a lengthy domestic relations case. It started in 2016. I was in counsel for Mr. Crandall at that period of time, and the cases went on somewhat of an odyssey. So there's Crandall 1, Crandall 2, and this would be Crandall 3. Crandall 1 was a remand back to the trial court to do certain things and for the domestic relations court to clarify its entry over certain dollar amounts and certain assets. At no point in time did the court reverse the judgment entry concerning a divorce. Crandall 2 sent it back, and what's unique about Crandall 2, when you read it, in the findings, it's confusing because it says that both parties waived the issue of further hearing, but then they reverse the remand order. So the way that we've interpreted this case is that if you have a remand from the Court of Appeals, it goes back to where it was, which is in the first Crandall 1 case. You don't go back and vacate out a judgment entry or divorce. And what's odd about this is that the court's magistrate seems to believe that when you remand a case back, you vacate out a judgment entry or divorce. This leads to horrible consequences. I've been doing this for a while, and I've never seen a court say that the judgment or a judgment entry or divorce on remand, you vacate out the actual term of the judgment entry saying that the parties are divorced. So in this particular case, the way if you follow the trial court's analysis, they're still married some 8 years into this divorce case. It's highly unfair in reference to this. I have a great deal of concern over what occurred, how it occurred. I'm the person that's trial counsel. This particular issue was troubling to me. The Medina court has always been a different court. They just open up their dockets. What's peculiar about this, they do not give you notices by email. They send it out by mail, but they'll send you a judgment entry by email, but they will do snail mail for notices. In this particular case, the court is wrong. It's a rebuttable presumption about notice. Did we get the notice of a pretrial? We didn't. I didn't get the notice. My client didn't get the notice. We filed affidavits. It's a rebuttable presumption in reference to this. This wasn't a trial date. This was a pretrial. The magistrate that was assigned this case is no longer with the Medina court.
Well, let's take a step back, if you
Sure.
The notice that was sent, and you're saying you didn't get it, and I appreciate that. Did it have the language, if you don't appear, the case may be dismissed?
It does.
That's what the trial court indicates. I've not seen the order myself yet. The trial court's ruling on the objections indicate that language was there.
Yeah, but it's not a judgment entry.
Well, I understand that, but at least
It's merely
I'm
a-
asking, you can argue about
Yes,
it.
it
I'm
does
asking the
say
simple
that.
question, was it there?
It
To
does
make
say
sure
that.
I understand that as I'm talking about things today.
Yeah, but normally
This was issued sometime in April, as I recall, and this was a June 7th pretrial.
correct.
When was the last time you had been in court before that April date? Was it a February trial that was continued? There's talk of an April trial that was set, but I don't know if you folks showed up that day or
There was
not.
a hearing over a prenuptial agreement, over what the issues were in reference to that. So at all points in time, throughout the 8-year odyssey of this case, counsel for Mr. Crandall appeared. Mr. Crandall appeared at everything. And so then you have a pretrial. It's a notice, it's not a court order. If you don't get the notice, putting you on notice that it could be dismissed, that seems to put you always behind this issue. There's no courtesy call, there's no emailing. The magistrate assigned to this case routinely emailed. Someone could have called. I gave a block letter in May saying I'm going to not be.
May of 24.
May of 24. Block letter went out saying I'm not available for these given dates. The idea that I wouldn't have filed a continuance for this trip And it's in the record. It was a trip planned with my son to visit.
The court indicates in its ruling on your objection to that, point to the case law that says counsel has an obligation to keep track of the docket. That at some point in time, you should have said, well, there's no pre-trial or trial date, you should have checked into that.
There was a trial date in August.
So the August trial date was issued by separate order?
I believe so. So you have the notice in reference to this, but where is it anywhere in any case that you can find that if you don't appear for a pretrial, you're going to dismiss out the case? And then there was this the whole orchestration of the dismissal of the counterclaim.
Can we talk about whether
Sure.
this is a final appealable order?
Yes.
We have Rule 41 that says dismissal for want of prosecution or lack of prosecution is an final appealable order on the merits. But then we have special rules, right, in 75 about this type of dismissal being not finally an appealable order.
Well, let me address that, but I wanted to make sure I reserved rebuttal.
Okay.
I did reserve it.
You have 5 minutes if you want to.
All right, so in reference to this, the reason why it's different in this particular case, because what was remanded back to the trial court. So you have Crandall 2 reversing the remand order. So the court in Crandall 2 reversed what the trial court did on the remand from Crandall 1. So it's different.
Wasn't Crandall 1 dismissed because it wasn't a final and appealable order?
It was.
And then Crandall 2, there wasn't a continuance granted or of some sort, and then that was reversed for that reason.
Correct, but the parties waived the issue of further hearing.
So there's never been a final appealable order that grants divorce in this case, is that right?
I would disagree.
Okay.
It's actually, in any sort of remand, you don't vacate out a judgment entry of divorce in reference to it. You can remand the issues of the particulars of a judgment entry, but you don't remand and vacate out a finding of divorce entry. That's never appealed.
But
The parties.
I'm sorry, Mr. Depp, if we were to say in this case, not a final appealable order, that would, it seemed to me, have the effect of going back to Crandall 1 and say, you still have this decision you made that's not a final appealable order, and the trial court have to sort that mess out at that point in time. But that would still exist, in your view, that 18 or 19 decision would still be sitting there to be resolved as not a final order.
Correct. That's what we've always maintained. And I understand courts change, judges change, people retire, people die. And so, but you still have to track it. It's very confusing. What's for you is whether or not the court, what they were doing to get a case that appeared to be an 8-year-old case off its docket. And so it's a gotcha moment, and the courts shouldn't be a gotcha moment. And in Medina Domestic Relations Court, that's what it's become. If you look at the orders that are issued, they're not uniform, they're unique. You don't get email notices of things, you get snail mail notices sometimes, regular mail the other time, and then you get email notices. So there's no consistency in reference to this. If we're saying if you miss a pretrial, does that mean in reference to this then every case gets dismissed? Or is it up to the court to decide whether or not they're going to punish someone or embarrass a lawyer for missing a pretrial, and it's up to the court? Is this a uniform rule for everyone that misses an attorney conference? Case is dismissed. Someone misses a pretrial, their case gets dismissed, or it's up to the court to decide who gets punished and who doesn't? This is embarrassing. It is unfair. And the only person that does this is embarrasses counsel. And it is embarrassing. But it punishes my client. What did Mr. Crandall do? And the question you have to ask Mr. Morris, if you have a counterclaim pending and you're representing someone that has an 8-year-old divorce case, why would you dismiss the counterclaim? Because remember, we still have trial set in August on this. You dismiss my complaint, you still have the counterclaim going. Why would he all of a sudden dismiss that out? It makes no rhyme or reason. If our job is to get people divorced, get them on with their lives, why would anyone do this? It makes no sense. And our jobs in every single divorce case, divorce the people, get them on with their lives, they come to court. The Crandalls are not sophisticated individuals. They're 8 years into the process. And under the current way, the way it's going to go, they're going to be 10 years getting divorced. on a marriage that is not lengthy. So they get married in 04, they come to court in 16, 12-year marriage, and now from 16 to 2024, 2025, they're still in domestic relations proceedings in reference to this.
Hasn't this appeal elongated the process? Like you could refile as soon as your case is dismissed and start another trial process, but now that you're here, we've made it, if this isn't a final appealable order.
I agree with you, but the issue is to tell the trial court, we go back to the 18 order, we don't go back and say that doesn't exist anymore. I have to file this in reference to it because I'm left with this idea that somehow, so let's say for instance, my client got remarried during this process after the 18. What do you do then? What if you do if there's transfers after that point in time? Do you say they're all null and void? At what period of time do you say to people that are into an 8 to 9 year divorce proceeding, you're able to move on? The consequences of this are severe, not only in this case, but all cases. I've never seen a court say, we're throwing out a remand order for a technicality in reference to any issue. And it does a disservice. So imagine that I do a refiling and I have to do the untangling of all of this to what people do after 2018. So you have 7 years of the parties that went on with their lives. How do you untangle that? Property transfers, automobile transfers, transferring things in reference to your estate, or issues like that. It makes no sense.
You have about 4 minutes. Did you want to reserve the rest for
I do. Thank you for reminding me. I tend to talk, so thank you very much.
Good morning, Your Honors. May it please the Court. My name is Attorney Adam Morris. I here represent the appellee, Liz Crandall, in this matter. Your Honors, this appeal should be dismissed due to lack of jurisdiction in this court. And even if this court does find that it has jurisdiction, the court's dismissal should be affirmed. Looking at the first issue, whether this court has any jurisdiction, the divorce was dismissed. There were no real temporary orders in the divorce. There were no substantial rights affected. There were no children that were impacted. So under the case law, under Smurs and Peak Sims, the case law in this district, this is a not a final appealable order. And
Well, I certainly agree it could be non-final, but how does that leave us, where did that leave us with Crandall 1?
okay, so
We had that decision that came out that we said way back when it wasn't final. So it's still a decision that floats out there. What are the parties to do and make up Crandall 1?
yes, Your Honor, thank you. If you look at the procedural history, Crandall 1 was issued in 2018. The court said it was not a final appealable order. The trial court then issued a revised divorce decree. So they've already taken out that first divorce decree. We go up on appeal on the revised divorce decree, and we maintain the argument that there was a lack of continuance.
Right, so, and the court reverses that decision, and that takes away the revised divorce decree, it seems to me.
That takes away, but the revised divorce decree takes away the first divorce decree, right? It's been
But the court says
superseded.
that trial was not properly done because there was a continuance that should have been granted, but wasn't.
Yes.
Doesn't that put us back to that first decree? In this particular case, we still have that first decree that's sitting out there that's not final.
Well, looking at the procedural, looking at the case law, the procedural history, the court has to go back to before that decree was even issued. Because
And Crandall 1.
in Crandall 1, the case law is that the trial court, you failed to grant the continuance. The case law says you have to go back to, at that point in time when you denied that continuance. So before the trial. Okay, so that's where we sat procedurally coming in to the new proceedings that happened last year. We were sitting before any decree was even issued. So unfortunately, these parties are at the point where there has been no decree issued. We were at the point where there was this failure to grant the continuance. So we're sitting there in 2017, right before the trial date. And that was the procedural posture that we were all sitting at. So the court had to redo the divorce, and they had to redo the divorce trial, and they had to issue a decree, and that would become the decree that could go up to appeal. Now we're sitting at the point, and Mr. Crandall, after this dismissal happened, he goes and files a new complaint for a divorce. Okay? So now he's asking the trial court,
Was
he's
that
up
before
here
or after you folks dismissed your counterclaim?
after.
So, I mean, what else was he to do? At that point, there's a dismissal.
Yes.
I mean, if he wanted to get divorced, he'd have to file a complaint for divorce.
Yes, Your Honor. But he's up here at this court trying to say that he was already divorced, and that there is some sort of decree floating out there prior that should be his divorce decree. And then he goes to the trial court and he files a complaint for divorce, which my client filed an answer counterclaim, and we're ready to move forward with the proceedings. These proceedings have now been stayed because of what's going on here in the appellate court.
As a practical matter, what's to be gained by your client by proceeding in the new case rather than this case? Obviously, we had that case before. We could go and do exactly what we're trying to do, is get a new decree. You could have went forward with a counterclaim in the 2017 case. What's the benefit?
As a practical matter, there's probably not that big of a difference. I mean, you're gonna get a divorce decree either one. We have to go back, we have to do the trial. Either one, there's probably, the issue that was going on in the previous case was that husband wasn't complying with discovery, he wasn't complying with appraisals, he wasn't doing things.
Well, even assuming that's true, what's gonna make him do it in this case?
Well, it just gives us more time.
Well, what about temporary orders and things like that? Was there, once the divorce is dismissed, all those go away, with the refiling, was it stayed before there was even any temporary orders or any other?
Yes, we filed a motion for temporary orders, it's been stayed.
Okay, so that, at least got to that process, you're saying?
Yes.
So those are still all in place, and they're similar to the one from before?
Oh, no, there are no temporary orders. Before we could even get to the temporary orders hearing,
Yeah,
the trial court stated because of this appeal is pending. So
I see.
basically, I'm sorry.
No, go ahead. Finish answering the question.
Yeah, the only thing that's been done in the trial court on this new divorce case is that the complaint for divorce was filed by husband, and wife has filed her answer and counterclaim.
Then
We
it's
are,
stayed.
yeah, and we are proceeding the temporary orders hearing, but it was stayed before we got there.
And at least if I understood your brief, and I haven't seen the full record yet, it seemed to me that there weren't any or very few temporary orders in the first case. There were no temporary spousal support. I don't think the children here, temporary support there. Were there temporary orders in that first case?
There were, I mean, there's I don't wanna say none, because I guess any order that comes out is a
Right.
temporary order, but there was no spousal support award, there was no kids issue, so it really had just been a spousal support award. That's something that we've really been fighting for, Ms. Crandall's been fighting for 8 years, is to try to get temporary orders, try to get an award of spousal support from the trial court.
And looking at the merit, I assume that tied up in the prenup and other issues that exist in this case, and whether or not there ought to be support, or is it another question other than how does the prenup affect potentially support?
The prenup does not affect support anyway. There's arguments about whether the prenup even affects a divorce in any way, because the prenup doesn't really discuss divorce, so that's.
I understood the trial court denied motion for temporary support.
The trial court had done it, and there was a motion to set aside regarding that issue.
Understood.
But
But at least, to be fair, there's, at least to end this conversation for now, there are no orders on temporary support.
There's no
temporary orders. There might be some temporary orders, it's a general, who should divide, who should do what, who can do what with assets, but there's no specific temporary orders on, you pay this, you do that, sort of thing.
Yes, Your Honor, there's no temporary orders in either case. There's no temporary orders on spousal support. I really don't think that this is that's right for, that this court has jurisdiction to deal with. At this point in time, we would go back to the newly filed case, and we would proceed with the trial court we pursued discovery and worked to get the case completed that way. And that's probably with all the procedural, this case has a lot of procedural history. And probably the best way is to start fresh in that new case and just move forward like a normal divorce would move forward. As the case law says, if there's things that in the prior case that husband thinks that should be brought forward, whether he wants to argue for de facto termination of marriage, he can argue that in the new case. That wasn't necessarily something that was brought up in the first case, but he could argue that in the new case. And anything, the court has extreme equitable powers. I mean, they can make sure that if there's things that they feel should be brought forward from the previous case, they can bring those forward. Going to the notice issue. I mean, the case law is clear that counsel has the duty to keep themselves informed on the docket. The court tried to schedule this hearing, and the notice went out, several months before the actual pretrial.
Did you file any response to his objections? Because the judge ruled fairly quickly, it seems to me, on that. Did you have a chance to file?
I didn't have a chance to. I didn't have a chance to respond. Quite frankly, it didn't. My client wanted more time to kind of get the discovery done and get everything completed that needed to be completed. But if we had to go forward, we had to go forward. The fact that they dismissed it, allowed us to file they filed the new case. My client was going to file a new case if they weren't going to. We were in the process of preparing the new case to go forward. But it was very clearly made to husband that he needs to attend these hearings. If he does not attend, then the court will dismiss it. There was a judgment entry.
I have a question about that though.
Yes.
Let's say that a judge did dismiss everybody's case. Don't you have a substantial right to be divorced? It's not like this couldn't be refiled over and over and over. We could have a case that got dismissed 10 times, and you certainly have the right to keep filing a divorce case. I mean, how do we decide where this begins and ends?
Yes, I agree with Your Honor that you have a right to be divorced. I think that that's an interesting issue on how many times you can file a divorce case.
If we say this isn't a final appeal order, wouldn't that be problematic that somebody could just keep getting their case dismissed and never be able to get divorced? Because it's not like a civil case where it could be refiled and at some point there's a statute of limitations.
Yes, Your Honor, and I think that you'd have the same recourse that you'd probably have if a judge just never sets a divorce trial, right? You'd have to probably go up to, file a writ or some other action to ensure that your case goes forward. I mean, that has happened in the past where divorce cases keep on getting continued, and eventually, some sort of action is filed in the Court of Appeals or the Supreme Court to force the case to go forward. So I think there would be remedies if that were to occur. I'd be hopeful that in Medina Court or any of the courts that the Medina deals with, that wouldn't occur, because I think that there are very good judges in our courts that will ensure that fairness happens. Here I discussed about the non-compliance by husband. There had to be an order to compel issued November 8, 2023. There had to be an order to show cause issued December 2023. An order to require access December 2020, access to the marital residence. Another order to show cause January 30th of 2024 for failure to provide compliance with the appraisal order. So there was a history here. There was a history of non-compliance with the magistrate's orders. And the magistrate even says in his order, kind of shame on me, I didn't put in there that your case will be dismissed if you don't comply with my orders. But I'm not going to make that mistake again. And he put that in his order that if a party doesn't attend, then their case will be dismissed, and that's what happened here. And you know, now's the time to go forward with the new divorce and move this case along. But this argument that somehow there's a 2018 divorce decree that stands is just not inaccurate. It's not an accurate view of a case law. The case law is very clear that that decree was superseded by a new decree that was then vacated by the Court of Appeals. And if that argument stood, then any time someone went up to the Court of Appeals, the trial court did a revised decree of divorce, because it was not a final appealable order, then there would be multiple decrees pending. It wouldn't make any sense procedurally to have several decrees pending just because the court had to issue a new decree because the first one wasn't a final appealable order. I think you have the information to make a decision. In conclusion, my client believes that this is not right for jurisdiction for this court, and that even if it is, that the trial court's dismissal should be affirmed.
Thank you.
Thank you, Your Honor.
You have about 4 minutes.
Thank you. Let me clear up some matters. I think counsel misspoke over the issue of temporary support. There was no temporary support order despite repeated requests in the lower court. There was one in the first time before the judgment entries, that was denied. You have the judgment entry of the 18 where they requested support, that was denied. The remand they requested it was denied. You have the second entry was denied. He requested it in this new case that was in front of Magistrate Collins, it was denied. So 5 times it was denied, contrary to this notion that, oh, we're going to do it again. It's been done 5 different times, all of which has been denied. What I find somewhat to be silly is this notion that you have a divorce case pending for 8 years, and counsel says he needed discovery in order to present evidence in a case. There was no issue of discovery in the first case, the second case, and the like. These issues
But there were some show cause orders issued by the magistrate.
well, there's
I mean, they existed and they were.
What's
Whether or
peculiar
not
about-
discovery needed to be done, they existed and there were show cause orders.
Well, I take issue with all that. If it's a discovery issue, there's no such thing as a show cause motion to be issued on the discovery.
Regardless, I'm just saying that to me is an indication that the magistrate recognized there was some discovery that needed to be done. That wasn't getting done. In the magistrate's view, you can dispute that, dispute the way he issued the order, but
I
the magistrate
understand.
felt there was some
I have a
discovery.
long history with Magistrate Collins and through the decades of his views towards me, Cleveland lawyers and the like, and it's in the proffer. He actually inadvertently sent an email criticizing me and Cleveland lawyers, and that's part of the problem.
And I know you attach and mention that in the appeal.
I do.
Those attached to your objection in the trial.
In a proffer, yes.
Okay, very good.
That there's, Magistrate Collins is no longer there, unique, and this was orchestrated. This is docket clearing 101 by any description. It looks like an old case. The court can rid itself of an old case by doing this. Yes, I'm embarrassed by this. Yes, I can be held accountable for it. But this courtesy, no one gets a courtesy call anymore. If someone misses here, do you dismiss their appeal because they didn't show up for an oral argument? People miss things. It happens. Last week it happened. Opposing counsel didn't show up. I said, well, it happens. You reschedule matters. But this idea that it's a gotcha court, which is now Medina Domestic Relations Court, if you don't file something by 3 o'clock, it's not docketed until the following day, even if it's email. Anything filed after 3 is docketed for the next day. The rules aren't fair. And I understand Judge Schaefer, I understand she was on this court, but this isn't justice. How does it, Mr. Crandall, how do you explain it to a fellow that wants a divorce? And Mr. Morris never answered. Why did you do this? Why did you dismiss out your client's counterclaim? So it's another 2 years?
What's the harm for Mr. Crandall? I mean, out of curiosity, it's a practical matter, if we do this divorce here or the 24 divorce, what's the particular?
Because you go back to the 18 divorce. There's already been a ruling on the prenuptial agreement at that period of time. Relitigate all of those issues? That's unfair. Tens of thousands of dollars spent before even my participation in this, 2 Court of Appeals decisions, and so now we say to the Crandalls, it's a 10-year divorce case. We're already at the period of time they filed in 16. This is now 2025. We're at 9 years. By the time it's done, we'll be at 10 years divorce. It's embarrassing for all of us within the system. Clearly, the Crandalls aren't sophisticated enough to understand this. How do we go to the common people and say to them, hey, this is what happens, because it's easiest? And I did cite,
Your time is up. If you could briefly conclude.
I did cite the DeHart versus the Supreme Court case from 1982 that says cases should be decided on the merits, that the local rules of court shouldn't be a landmine for determining issues. And I did file it, and I did cite that case, because that's exactly what this has done. 40-some years ago, it addressed this. Thank you.
Thank you. The court will take this matter under advisement and issue a ruling in due course. The clerk of courts will mail you a copy of the opinion on the day it's released. The opinions are also available on the Ohio Supreme Court website. Thank you both for your presentations.
Thank you.